Hi everyone. Today we are going to present to you the Occupational Safety and Health Act 1994 from the Part 5 to Part 8.
Part 5 General Duties of Designer, Manufacturer and Suppliers. Section 20, subsection 1 to 3 state that the plant is designed and constructed to be safe and without risk. Manufacturer is responsible to carry out testing and examination for the performance of the plant before employees use it. Adequate information about the use of plant is provided, such as user manual or direct instruction. This is the example of user guides for the boiler. Manufacturers should also carry out research to eliminate and minimize any risks to safety and health that their design plan might give rise. There is a case occurred in 1972 where and Dunlop Rubber Company Limited Company. The plaintiff claimed that they had contracted cancer of bladder as a result of being exposed to chemical containing carcinogenic substances manufactured by second defendant, which is Imperial Chemicals Industries Limited, and sold to the first defendant, which is Dunlop. In 1996, plaintiffs were diagnosed as suffering from the disease. Both defendants denied negligence, breach of duty, and causation. The Court of Appeal held that the manufacturer of a chemical product owed to the purchaser's employees a duty to take all responsible steps to satisfy himself that the product was safe in the sense that there was no substantial risk of any substantial injury to health on the part of persons who were likely to use it. Section 21, subsection 1 to 2 state that manufacturer or supplier must ensure the substances that they provide for use at work are safe and without risk to health and carry out testing and examination of the substances to ensure the safety. They are needed to provide sufficient information about the substances supplied to users, especially about the any risks to which their inherent properties may cause. For instance, substance involved chemicals should include chemical safety data sheet. Manufacturers should also carry out research to eliminate and minimize any risks to safety and health that their design plan may give rise when used, handled, processed, stored, or transport. Section 22, subsection 1 to 5 state that manufacturer is not required to repeat testing or examination if it has already been carried out in so far as it is reliable. Duties imposed on persons under this part shall only apply when things are done to carry out trade or business or other undertakings and to matters under his control. Manufacturer or supplier can get a written undertaking from the client with that the client will take specific steps to ensure that plant or substances will be safe and without risk to health in order to minimize their obligation. Manufacturer is only responsible if the employees properly use the plant or substances according to instruction and advice made available. It protects manufacturer from liable to any misuse by the employees. Section 23 states that fine not exceeding 20,000 or imprisonment for a term not exceeding 2 years or both shall be imposed on person who fails to comply with this provision. Part 6. Appointment of independent inspecting body.
Under this Act, the Director General has been given the authority to appoint and pay a person or inspecting body who does not involve in any industries to advise him in carrying out the object of the Act. For example, he may appoint an independent body to investigate major accidents and give expert opinions or carry out medical surveillance. A person or independent inspection body appointed by Director General shall be given allowance, fee or reimbursement which is determined by Minister. An officer appointed by Minister under subsection 5 Part 2 and a person or independent inspection body appointed by Director General under subsection 6 Part 1 should be under control, supervisions and directions of Director General. Director General or officials who is appointed by Minister under subsection 5 Part 2 and a person or independent inspection body who is appointed by Director General under subsection 6 Part 1 shall be considered as public servants by following the means of Penal Code Act 574. The Penal code covers a very wide range of offences, and offences by public servants are specifically mentioned under Chapter 9. Sections 161, 162, 163, 164, and Sections 165 that would take public servants to task for offences that are related to corruptions.
In Section 28, medical surveillance is also meant by medical control or supervise. It is applied to any ministry, any industries, or any class of industries where he may make regulations requiring reasonable arrangement specifically for the medical surveillance and examinations, but not including medical treatment of a preventive character for his employees if he involved in below situations. A. Cases of illness that caused by nature of process or conditions of work. Changes in any process or substances used in process. For example, new process, new substance introduced, which will be risk of injury to health of a person and brought in the process. C. Person below the age of 16 years old, which embroiled in work that may cause risk of injury to their health. D. Occupations specified in the third schedule which may be risk of injury to the health of a person or any substance or material brought by the industry to be used or handled therein or from any change in the conditions in the industry. Regulations made under this section may require the medical surveillance to be carried out registered with the Director General and may prescribe the qualifications or other conditions which are to be satisfied in order to be registered for the purpose of this section. A person who contravenes the provisions of this section or any regulations made under shall guilty of an offence on convictions liable to a fine not exceeding 5,000 ringgit to or to imprisonment for a term not exceeding 6 months or both. Section 29, Safety and Health Officer. This section shall apply to such class or description of industries as the Minister may, by order published in the Gazette, specify. An occupier of a place of work to which this section applies shall employ a competent person to act as a safety and health officers at the place of work. The safety and health officers shall be employed exclusively for the purpose of ensuring the due observance at the place of work of the provisions of this Act, and any regulations made thereunder, and the promotion of a safe conduct of work at the place of work. The safety and health officer shall possess such qualifications or have received training as the minister may by notifications in the Gazette from the time to time prescribed. An occupier who contravenes the provisions of this section shall be guilty of an offence and shall on convictions be liable to a fine not exceeding 5,000 ringgit or a term of imprisonment not exceeding 6 months or both. Section 30. Establishment of Safety and Health Committee at Place of Work. Every employer shall establish a Safety and Health Committee at the place of work in accordance with this section if there are 40 or more persons employed at the work place. The Director General directs the establishment of such a committee at the place of work. The composition of a Safety and Health Committee established under the subsection 1, the election or appointment of a person to the committee, the power of the members of the committees, and any other matters relating to the establishment or procedure of the committee shall be as prescribed. Every employer shall consult the Safety and Health Committee with a view to the making and maintenance of arrangements which will enable him or his employees to cooperate effectively in promoting and developing measures to ensure the safety and health at the place of work. In checking the effectiveness of such measures, a person who contravenes to these provisions in this section shall be guilty of an offence and shall on convictions be liable to a fine not exceeding 5,000 ringgit, to imprisonment for a term not exceeding 6 months, or both. Section 31 talk about the functions of Safety and Health Committee. The Safety and Health Committee established at the workplace pursuant to Section 30 shall keep under review the measures taken to ensure the safety and health of persons at the work of place, shall investigate any matter at the place of work which a member of a committee or a person employed thereat considers is not safe or is a risk to health, which has been brought to the attention of the employer. Besides that, the Safety and Health Committee shall attempt to resolve any matter referred to in the paragraph B, and if it is unable to do so, shall request the Director General to undertake an inspection of the workplace for that purpose, and they shall have such other functions as may prescribe. Part 8. Notifications of accidents, dangerous occurrence, occupational poisoning, and occupational disease, and inquiry. In Section 32, notifications of accidents, dangerous occurrence, occupational poisonings, and occupational diseases and inquiry, an employer shall notify to the nearest Occupational Safety and Health Office of any accident, dangerous occurrence, occupational poisoning, or occupational disease which has occurred or is likely to occur at the place of work. Every registered medical practitioner or medical officer attending to or called to visit a patient whom he believes to be suffering from any diseases listed in the third schedule of the Factories and Machineries Act 1967, or any disease named in any regulations or order made by the minister under this act, or occupational poisoning, shall report the matter to the Director General. In Section 33, the Director General may direct inquiry to be held if, in the opinion of the Director General, an inquiry ought to be held into the nature and cause of the accident, dangerous occurrence, occupational poisoning, or occupational disease. He may cause such an inquiry to be held by an occupational safety and health officer. The Director General may appoint one or more persons of engineering, medical, or other appropriate skills or expertise to serve as assessor in any such inquiry. Every person not being a public officer serving as an assessor in the inquiry may be paid an allowance at such rate or rates as the minister may determine. In Section 34, power of Occupational Safety and Health Officer at inquiry. For the purpose of holding an inquiry under this Act, an Occupational Safety and Health Officer shall have the power to administer odds and affirmations and shall be vested with the power of the first-class magistrate for compelling the attendance of witnesses and the productions of documents, maintaining orders and otherwise duly conducting the inquiry, and all persons summoned to attend the inquiry shall be legally bound to attend.